The outcomes and the approaches and the policies on DUI charges are pretty similar in Alexandria and Fairfax and Prince William. To some extent, Arlington. Each place does what they call their blood docket differently. Those are DUI cases where the evidence of intoxication has been drawn from someone's blood as opposed to their breath. Each place has their own calendars about when those particular witnesses will come in. Those are pretty different sometimes. But breath test DUIs or DUIs that don't have that because they had refusal charges as well are all pretty much the same. You get pretty much the same offer, which is something very close to, if not exactly, what the mandatory minimums are by law. Those would be a mandatory minimum fine of $250, and we're talking about first offenses here. There's no mandatory minimum jail time if you do not have an elevated blood alcohol level. If you have the first elevation, it's 5 days mandatory. If you have the second, it's 10 days mandatory. You have to go to Alcohol Safety Action Program, which is called ASAP. You have to have an ignition interlock by law on any car you're driving. If you are requesting a restricted license and your license is suspended for 1 year, again, that's by law. There is something to watch out for in Loudoun, which is Loudoun has a local policy on what they call enhanced DUI probation. So when you are put on probation, there's a component called good behavior, which is you can't pick up any new charges for a certain period of time after the case is over. Otherwise, you risk your jail time being imposed. Loudoun puts you on active probation as opposed to unsupervised probation. And the active probation requires you to sometimes go meet with somebody, maybe take some urine tests or some breath tests, and there's more associated fees with that. That's sort of a rude awakening for a lot of people that didn't realize DUI is treated stricter in Loudoun. Fauquier is probably the strictest. I don't think they have any official policies like Loudoun does, but in general, if you get pulled over in Fauquier, even for infractions, even for speeding, resting on the shoulder, generally they are not going to just dismiss those if you take a driving class. There is one judge out there that's been there for years and years in the misdemeanor and traffic courts, and so he always pretty much does what he's been doing. Loudoun has 2 or 3 judges in their general district court. Prince William County has 4 or 5. Fairfax has 8 or 9. Alexandria just has 2. And then the towns of Herndon and Vienna and the city of Fairfax draw rotating judges from Arlington and Fairfax. The Arlington General District Court has about 3 judges. So the more judges you have, the more diversity in approaches and things you potentially have. As far as reckless driving goes, again, you have the same breakdown. You have pretty much the similar stances in Alexandria, in Fairfax, and in Prince William. Arlington is a little bit stricter on reckless drivings. They do not accept all forms of the driving improvement courses like most places do. They're also a little bit more reluctant to break down traffic infractions or dismiss traffic infractions as well as reckless drivings. Fauquier is also a problem in this respect. They will almost never break down an infraction. Sometimes you can work with the prosecutor by agreement to get down from a reckless driving. Loudoun is sort of in between all of that. They are open to it, but they don't really have policies, and it really depends on which judge is presiding that day and what the prosecutor thinks the judge is going to do. There are some procedural differences no matter what your charge is. So for example, in Prince William County, By policy, the prosecutors do not subpoena any civilian witnesses for accident cases on the first court date. So if you come on the first court date and you want to plead not guilty and have a trial, it's not going to happen. They're going to ask for a continuance and the judge is going to give them a continuance. Even if you took off work, even if they didn't give you all your discovery evidence that you should have gotten, that's just by policy. A lot of places don't have that policy, but the same thing is sort of happening. It takes the Commonwealth a little bit to get people to court. The judge will give them, one or two chances to do that. But generally, the busier the place is, the less patience they have for that. So Fairfax, sometimes you will see cases thrown out because the dockets are so big and the judges have other things to do. And a lot of cases can be brought back by the Commonwealth after they've dropped a charge, if it's still within the statute of limitation. Another procedural difference, this is important in Alexandria, is they have for marijuana cases, well, in general they have advisement court dates, which are basically extra hearings to tell you about your rights to have a court-appointed lawyer or a public defender or a private attorney. They also, a lot of places do this too, they will set status or review court dates, which are not trial dates, but they're after your arraignment, and they are there to see, did you hire a lawyer yet like you said you would? Do you need to change your decision about that and have one provided for you by the court, etc. Alexandria also sets a status date for possession of marijuana cases just to see if you're eligible for the first offender program and just to give you the required marijuana discovery. And you can work a case out on those days if you want to do the program, but if you don't, typically the officer isn't even there and they will move to continue that to another trial date.